federal, state, or local law. So that's in the, hold on, that's in the statement of conditions of release. The minute entry would not have said that itself. The minute entry only says he's granted release with these conditions. It doesn't go through the standard condition. He's alleged that he violated the standard condition, and he violated no state law.
And I still think the better argument was there was official Monday, or at least a good argument. Now I'm starting to think the better is the other way around, is we'd also like to address, because we could do transfer courts. I want to again say there's a comma. There are three, it's not one sentence, it's three specific scenarios. We also would like a chance to argue at a rehearing of why there was not proof evident of these things, these last two felonies. It's not just about it. I mean, I thought at the time, and I still believe I was correct in thinking that, given the situation on short notice, the best argument to focus more on was that a pre-trial release was not official. Now that I've looked into the evidence more, I'm realizing, the better argument is that no felony even occurred. And he's entitled to a rehearing that as well. As the court acknowledges, people make that request all the time. Why is this any different? I also made a constitutional argument, if you look at my reply, is yes, the Supreme Court, they can't really indicate, Bricknell, whatever, there was a Supreme Court decision saying that upholding the denial of bail, saying it wasn't unconstitutional statute on the whole. But what it didn't say, it was that each individual couldn't come in and make a constitutional challenge. So that's why I want a hearing as well. And I bring up the problems at the jail where he's deprived of the law library, the monitoring it. This is a very unique situation. Mr. Myers needs people to help because advice on challenging the statutes is different than any other crime. Hold on, Mr. Myers, get in there. There's a lot of arguments I raised in addition to this first one. I just want to address all arguments. The other thing that I'd like to address at the rehearing is the facts now is, and I'm going to talk to Mr. Myers about it. This court is a lower court. The court feels it's bound by the Brown despite the change in statutes. And I understand the court's side as a reasoning believes that's still binding law and it's our duty to then go to them and have the court of appeals changes. But I hope the court, at least, I think the court does, because you're asking questions of everyone, understands the dilemma here. Part of the argument I'm going to make for bail here is this situation is much better decided before trial on a special action rather than hashing this out on what is going to be the messiest of trials. And we have again, I'm going to request your instructions. The state's going to object. I have no idea what the court's going to allow or not at that point. If the court grants release conditions, and it can be extremely stringent, and I'm going to make the argument, constitutional argument, what we can do then, we can postpone this trial, and we can then out of custody, so Mr. Myers is not prejudiced, special action, the court's decision, and let's see what the Court of Appeals thinks. They can revisit their own decision on this new statute. That's fair. Well, I'll tell you what would not be fair, Your Honor, is for the court to say we have to go to trial under this, what we believe to be unconstitutional, and it may be. We don't know how the next court's going to rule. And now he sits in prison or sits in jail while it takes me 60, 90, maybe 120 days to get an appeal done. I'm going to get help. There's already organizations contacting me. They want to be part of this appeal based on the First Amendment issue.
Definitely.
And I need time. I need a couple months, a few months even. This is going to be it's going to be an epic published appeal, Your Honor. I think the court believes that to be the case as well. And Mr. Myers should not be in jail or in prison or in custody battling out whether this statute is unconstitutional. And I'll be making that argument at the rehearing, but I'm just saying all the reasons why I'm going to bring up that there is a second part of what the court believes is fairness, the constitutional grounds of granting bail based on facts. And that's what we're saying. Now, if the court...
Hold on. So Judge Miller looked at the evidence that the state had presented as to the new charges. And what I don't hear you saying is that that's going to change. So it would, hold on, it would just me being the second guessing Judge Miller, which to me doesn't, I don't think what the statutes or the rules directed at. It says you do new evidence. Hold on. New facts, something that wasn't already considered. You see what I mean? I don't want to check her work basically. I'm not intelligent.
It's, and I understand in circles, Myers. No,
I want to hear from Mr. Parvin.
Why can't I speak?
Because it's his motion that says to the new case. And just, I want to hear from him. This is a very technical point.
I know, and it's just talking in circles. It says, it says if it's transferred to the court, you can get a hearing, and the court can order a new evidentiary hearing and you can find proof evident or not. It's clear, it's black and white.
I read the rule differently. You are. Go ahead, Mr. Parvin.
Yes, That's an interesting point. I think it's similar to having how you have 12-person jury. People might have different opinions on the evidence. And I think we were in a rush there because we had to have the bond hearing immediately. And yes, Judge Miller did find proof evident based on what she interpreted the statute to be. I would hope this court might have a different interpretation of what knowingly means. And this is my concern of the statute in general. I don't know what Judge Miller's definition of that statute was. I don't. It's too hard to figure out. I don't know what this court's definition of what knowingly acts. For all I know, Judge Miller might have agreed with my interpretation of how the statute reads, that you're guilty even if you knowingly act. Sounds like this court disagrees and thinks, well, give me a jury instruction, but I don't know. I don't know what Judge Miller thought. That's a problem. We'd have to have a hearing on the evidence there. I'm not saying you need to overrule Judge Miller. I'm saying maybe there would be a different opinion on the facts. But really, when I'm saying I'm focusing now more on this, I thought like the conversation, some of the things come up is the big issue is we need to get to appeal on this issue. And I think the court agrees. So I appreciate the court not wanting to overrule Brown because they're not, but Mr. Myers should not be in custody while that's found out. We should be given a chance constitutionally on this argument. We've made a very powerful case. I think the court acknowledges we've made a powerful argument. This should be fought out on a special action, and I think the Court of Appeals definitely will take this one, Your Honor, as first submission. We'll have the help we need. Now, if Mr. Myers is released, contingent on the special action with this issue, and he makes any videos, he so much as just, goes on social media whatsoever, does anything, back in there he goes. I think that'd be fair.
Mr. Niles, Mr. Myers being in jail, preventing him from filing special action, as we all know. If the Court of Appeals takes the losing party to file a petition for review, it's a long process that he would sit in jail while this First Amendment issue is being hashed out.
Your Honor, Mr. Myers made a choice. He was out on release on the first case. He was released to pretrial services. He was out and he could have litigated. But what he did is he goes home, and then within that weekend, he goes and he does the same conduct again. He keeps doing it. So he doesn't get to just keep violating the law while he's on release and get to be out in the community. That's what this law is designed to do, is the Constitution has, if you commit a new felony, there's a standard given to the state in order to be able to prove that. The state
a jury gets to decide whether or not he committed a new felony. This is just an allegation, and the judge can only determine whether or not there's a reasonable likelihood of success if it goes to trial.
But on the evidence, it's the same evidence that would be presented if the court kept having the hearing over and over again. It's the exact same evidence. What the defense is asking for is just for this court to basically just review Judge Miller's work and then say whether they agree with her or not. And that's not appropriate.
In your position that there's no wiggle room at all, if you commit an offense and the state can prove it at this bail hearing, then the judge has no discretion that they must hold them. They even say, hey, I believe the state's case, but I think that there are release conditions that could protect the community. Even if the judge finds that, are you saying that the judge could not release the person no matter what?
Correct. No. So that's under the Arizona Constitution that states that. And then even under Rule 7.4 and talking about the procedure, it talks about if the court, so it's under either 7.2 B1 or B2 to deny bail, the court must order the defendant held without bail until further order. It doesn't give a discretion. It's a must.
Not forever. Calm down. I'm going to get on to
How could there be a further order now? Mr. Myers, just let her talk. She's just citing a statute, okay? Just our rule.
So why don't we just go to sentencing? Calm down.
I mean, I'm guilty of a felony. You're saying I've been found guilty of a felony. So let's go to sentencing.
I think we're going to get some good
But we're working through this issue, so just let her talk.
And then, Your Honor, under Rule 7.2, under right to release, when you go under B, it talks about before conviction, defendants charged with an offense not eligible for bail. And so it talks about under B1, it says not eligible based on commission of a specified felony or any felony while on pretrial release.
What rule are you reading from?
So this is rule 7.2. And this is under B, and I was reading from B1.
Okay, hold on, let me get there. B1, okay.
It says, and then it says a defendant must not be released if the court finds the proof is evident or the presumption great that the defendant committed. And under B, any felony offense while the defendant was on pretrial release for a separate felony charge.
Okay.
So there's no discretion. It is, the law requires that he be held
So
without.
must is required. Okay.
Yes.
Yeah, Mr. Parvin, Mr. Myers, just let Mr. Parvin argue. We're just talking about what the meaning of the words of these rules are.
So, hold on. No, I know we're gonna get there. So, state's not correct. I mean, so the state is correct on the statutes. Here's the problem though, and I think the court's picking up on this, is there are different interpretations of what knowingly means. What we don't know, and I don't know, I didn't ask her. I don't know, and I didn't get the request jury instructions for a bond hearing. I don't know if Judge Miller thought that my interpretation is correct, because I believe, if you ask me, so, you can get mad, I mean, other people listen, get mad at me all want. I think the statute says you're guilty just because you knowingly acted. I may think the statute's unconstitutional, but if I were on a jury, I would still find guilty because I have to follow the law. That's my
Right,
interpretation of the statute. I would find guilty, even if I didn't want to. I'm not going to use jury nullification. All right. So I know you would. I'm explaining my interpretation of the statute. I would still find guilt here. I may not like it. I wouldn't want to. Now, it sounds like, and that's great, that the court may have a different opinion than me and think that the statute does give knowingly on both counts. Maybe this court would, find differently. But here's the problem. I don't know what interpretation Judge Miller used. Did she use the one I believe, that he's guilty? Or did he use the one that your court police statute says, which permits, all the evidence? Was it knowingly? I don't know. That's why we need another rehearing, because I'm not even sure which standard I'm allowed to argue now. I'm confused, to be honest, I am. That's why I filed the motion to dismiss. So at the rehearing, we could discuss what standard the court's going to use for the statute and really determine, was there proof evidence of these two offenses? Because really, one was just showing public information about explaining why this was easily accessible. The other was showing, defending himself, an injunction of why he's appealing, explaining law. And again, that's all I'm asking on that end. We get a rehearing because the court may have a different interpretation of what the statute means. And again, this is not something I had time to come up with, because I've had to research the statute. I'm just telling how I believe. Sadly, I think it means he's guilty under the statute. That's if I were the jury, that's how I would read it. But again, I hope other jurors don't find different. But now the other point, this is one point I'm trying to explain to Mr. Myers here, is we have a real problem on special action. I think everybody agrees that the Court of Appeals needs to look at this issue under the new statute. And I was really hoping this court could disregard Brown and say, this new statute, I can be the first to act. I think the court is making a well-informed decision, believing that it's not my job to do so. That needs to be the next court. All we are asking, if that's the court's ruling, and it's a good ruling, Judge, permit us out of custody to special action and give Mr. Myers full knowledge. The only thing Mr. Myers will be allowed to do with the computer is to help in his defense on the appeal, so we can talk about it. There'll be no more posting in social media. You can make the most stringent conditions. I think I even mentioned potential house arrest, although he needs to be able to go, grocery shopping and other things. That case I've cited, the state cited, Arizona Supreme Court case that upheld this. Again, it didn't say that the court could never find a constitutional issue where release would be appropriate. All it said was the statute as a whole is valid. Similar to the state's argument, the state argued that Mr. Myers doesn't have standing and that the statute itself is valid. I disagree. I think he does have standing, but that was what the Supreme Court was saying, is that on its whole, it's valid. But then it went on a case-by-case situation. Each individual judge can review the constitutionality as applied to a defendant. And I think the court agrees. In this one exceptional case, because we need to go to appeal here, there should not be a trial before this is solved, Your Honor. Release conditions constitutionally, and you could cite the Arizona Supreme Court in your ruling of why you're doing it, that you're finding in this case only it's constitutional to grant Mr. Myers release. Again, maybe on house arrest with permission to go to grocery shopping, just, you know, to leave the state's concerns. And, you know, if this appeal takes, you know, 120 days, few months, maybe if Mr. Myers is doing well on house arrest for, you know, 90 days of that, then I can file a motion to modify and be continuing off house arrest if, you know, if all the appeals pending. I'm just offering one step at a time.
So let me, Ms. Park, let me interrupt you real quick. Okay. Well, I would like to do some more research on this issue of whether committing offense while on.
So here's what's going to happen, guys. How much do you want to bet? The judge is going to take the matter under submission and probably call a rehearing today or tomorrow. This is typically how the stuff goes when you raise serious issues of law. What do you guys think? Let's listen.
Release can never be bail eligible. What if we came back later in the week to continue this argument after I've had a chance to read some of these cases?
Your Honor, I start a trial tomorrow that goes for 2 weeks.
Of course she does.
Mr. Myers, Your Honor, with 2 weeks.
Well, this.
And Your Honor, what I point out is that the defense has
She already had this all made up because why? Because she knew the court was going to take it under submission.
presented zero case law that says that he is eligible for bond following that finding, the proof evident presumption great. They have cited zero case law.
He doesn't have to because he's raising a novel issue of constitutional law that obviates all of her arguments.
What they're referencing is a rule that says may. There is no must. What I'm
Irrelevant.
referencing are the rules that say it is must. And it is an offense that is not bailable. And so they keep talking about offenses that are bailable as a matter of right. This isn't a different category. And it's built, it's there. It's in the Constitution. It's in the rules.
If the statute's unconstitutional, everything she's saying is irrelevant.
That's what I'm going to do. I'm going to tell
There's the Supreme Court gave you permission if you find a constitutional issue, you can't release. That's what I'm saying.
Mr. Myers, hold on.
Please let me say something.
What do you want to tell? Okay, go ahead.
7.2, she just read it. It says until further order. And then 7.4 defines the conditions that allow the judge to make that further order. 7.43, transfer to a new court, new facts, or money.
So
That's the conditions that allow you to make that further order. It's not statute and case law. It's literally the rules of procedure.
Okay.
7.2, you find proof evident until must be held until further order. Well, how could there be further order? Oh, let's go to 7.3 or excuse me, 7.4, which is the definitions of what there's only 3 ways there can be a further order: a transfer to a new court, new facts, or the money is too high. Those are the reasons that you can get a new order. We're
Okay.
we're being talking in
Why?
circles.
Mr. Myers, I've explained
It
why.
literally says until further
Mr.
order.
Myers, I
And then it
think-
says, here's how you can do that.
Understood. I'm just saying, read the Arizona Supreme Court decision where you
Here's what I'm gonna do.
find an individual constitutional basis to release them based on this huge appeal we need to do.
I'm going to take this matter under advisement and read those cases. And if I believe that we need to set another hearing on bail eligibility, I'll have my JA reach out to counsel and we will get it scheduled at some point. But I want to read I don't want to rule against you, Mr. Parvin, right now, because I want to read those cases. I would prefer to just set a hearing, continue this on Friday. But hold on, but this will give me a chance to review everything. That if I think that we need a hearing, we'll find a time that works.
Friday does not work for me. It's the only day it does not work.
Yeah. So, the Styles is starting a trial. We'll have to find a day that works. But I want to read all this first. There's a lot of paper in this case. I think I got through it all, but I didn't get the depth on this that maybe I think I can get by reading this stuff more closely.
May I ask one last thing?
Sure.
I just want to end. First of all, I think I've explained why I don't know what how the trier fact is going to treat that. I don't know if Judge Miller agreed with my interpretation or perhaps yours. Nor should you say your interpretation.
Right.
But I'm just saying that'd be something I would need to know if we're arguing, for proof evident. That's a real problem. Why I don't think we got a fair hearing.
Right.
Now, the biggest concern, I really believe, if you review the Arizona Supreme Court decision, the state cited it. It was, where is it? Moreno versus Brickner.
That's in their response.
Yes, that's the one approving the statute. And what it left open was the opportunity for a court to find an individual constitutional basis as applied challenge.
Okay,
So what I'm saying,
Right,
in
as
addition to all the
applied.
arguments I've made, so why I think we should get a rehearing based on whatever this court's interpretation of knowing is, it may be different than mine, I hope it is. But the biggest argument for release is so we can appeal out of custody and do this the right way, Your Honor, rather than rushing a very messy trial. And the Arizona Supreme Court has given you the discretion to find a constitutional reason to grant it as only applied to Mr. Myers, as if you would not be able to let anybody else out. But you'd be able to let Mr. Myers out because he has this appeal, which, as the court, I think, agrees, needs to be heard fast.
okay.
How can I be guilty?
Hold on, Mr. Myers, we made the argument. We made the argument, Mr. Myers.
All right, so then.
What about this
um,
pretrial stuff?
The last, that's a good question, Mr. Myers. So Judge McDonald set a trial in July on the new case, correct?
So, Your Honor, he did not.
Oh,
And
Well, in this case, he did, because I agreed to it.
July 21st.
But, okay.
on the new
so
case.
we were trying to get the trial set, and then there were all these objections to trial being set. And so I don't think anything's happened.
Said it.
I saw a minute entry though.
Said July 21st.
Hold on,
Literally said July 21st, and then he said we could always move it up.
Okay, hold on. So in the hearing on the 15th,
He said he was postponing the one that I'm the lawyer. Because I had some pretrial issues I wanted to talk about first, and he said in that one,
the minute entry isn't clear, but I think the intent was that the second case, we'll call the Department of Defense case, that was set on the 21st.
yes,
That's in the minute entry.
it was.
Your Honor, that's what we were trying to do. And we were trying to get the cases set for trial, and then Mr. Myers kept objecting to trial being set because he wanted trial set much sooner. He asked for in a week.
In my case.
And
Okay.
so that's how this got, but I mean, ideally, we're gonna consolidate the cases, but that's a different.
Just let her talk. She's giving her,
In circles.
but you have to let her talk and then you gotta talk. Go ahead.
So the reason why we're not taking up the motion to consolidate is because Mr. Myers says two different things. One, he says he wants a bunch of different trials to take up the separate issues, because he's said that there's going to be many, many trials of, with the different counts.
No.
Which
No, just let her talk. No, just let her talk. You'll get a chance.
I know, but I want to clarify that because your argument is incorrect. What I was saying is appeal, like a new trial, like post-conviction, remanded for new trial, not different charges, new trial. That like will have.
So this is a real problem, by the way. Every time Lynn interjects and cuts people off, it sort of prevents people from getting to say their side of the story, and it makes them look really unprofessional, which he's allowed to be because he's pro per, but it doesn't help him. So the way it works, guys, is when you're in court, you let the other side finish, and you take your pen and your notepad and you mark down each thing that she's saying, and you listen diligently, and you let the other side speak. And then you address each point she made point by point. But what he is doing is typical of a lot of non-attorneys who have a very fast processing speed. But it's hurting him with the court. It's hurting him badly, and it will destroy him if he does this in front of a jury. But let's keep listening. I'm just trying to explain to you, look, I love the guy. I think he's a very smart guy. But this is wrong. This is not a good look for him.
Have the first trial, and then if it gets appealed and sent back for a new trial, we'll have a new trial.
Okay, all
Not
right.
severance.
So have you filed a motion to consolidate yet?
I have not, so we are dealing with an issue where we've got Mr. Myers is representing himself on one, Mr. Carbon on the other. And then the motion to consolidate is dealing with both those things. I want to make sure, one, that he understands what that all entails, the motion to consolidate.
I'm about to do that in 5 minutes when she's done.
All right, hold on. Go ahead.
So that was the issue, is because I've heard different things coming from him. So I want to make sure he understands, because sometimes the language he's using suggests that he's wanting a motion to sever counts. And then another thing says he's wanting to
Okay.
join them. And that's why there's some confusion there. And then also when we were in that hearing to set trial, then it was getting separated out, like, you know, he wanted them separate and one needed to happen before the other. And so I think Judge McDonald, you know, he was just coming in to set a trial, and then there were a lot more issues going on than he was necessarily prepared or informed to be able to deal with.
Okay, let me ask Mr. Myers, in the second case, the newer case, are you going to ask to represent yourself?
Well, we wanted to see what happened with the motion today, right? Obviously, so our plan was, hear this motion, right? Mr. Parvin filed a great motion. We're gonna see what you rule, right? And then we gotta have, you know, put our heads together. Okay, are we gonna appeal? You know, it's like, if you grant it, obviously, the case, you know, dismissed, whatever, right?
Right.
And so then it's like, we don't need to have a forever, we don't need to set a trial because there's no trial because the case goes. And so that's kind of like why we're waiting, trying to get this settled as fast as possible, the motion for that, right? And then now so then it was like, well, what's that leave us? That leaves us with the remand, right? Which I please grant an extension on that one too.
On both.
Yes, and so then it's like, okay, what's our next strategy, right? Okay, do we want to do the remand or the special action? But based on this, we're gonna do the special action. So it's like, okay, my thing is basically, once we get, like, I know you said that, I take what you say serious. You said, you know, we're not gonna go back and forth. He is my lawyer, he's not, you know what I mean? What I'm saying, obviously I can't do the special action from jail, right? So that's, we're hopefully gonna address that. But, you know, now that adds another thing in, like, okay, well, today, you know.
Yeah, it's like he wants to do a special action, but he doesn't want to wait for weeks and weeks and weeks to see if the upper court's going to hear it.
We were gonna, you know, if hopefully get
while he's locked up.
Dismissed. Then now it sounds like we're gonna do special action. We're gonna have to keep them on a little bit longer. But then it's like, okay, that'll continue the trial date, you know what I'm saying? I'm willing to waive the speed for that, right? Now, if then he would still be on there, right? And then once we would have come back, you know, the special action would get ruled on, it would either, you know, granted, the firm send back, you know what I'm saying? Then we'll be back in here, right? And then so it's like at that point, then once he runs with the special action, then it's like, okay, well, what else is there to do? That's when I would take over. Like, because you get what I'm trying to say is, like, I'm gonna be the one that questions Shannon Walker under oath. I'm not giving that right up under any circumstance. So I've been waiting for that my whole life. And so that's gonna happen. And so that's why I want them consolidated under 13.3C for judicial efficiency and interest of justice. And Rachel said at the couple of hearings ago when you were here, oh yeah, we want to do a consolidate. And I said I would stipulate to that. And then I heard it with my own ears. Last hearing with the Judge McDonald, the judge asked her, will you please do a motion to consolidate to help the court do, you know, resources scheduling? And she said no. That was before the hearing. That was off the record 7 minutes before the hearing started. So for her to come in, this is what I'm saying, she talks in circles. Then she said, well, you know, no, I didn't say nothing about sever. I said, if I don't get the right to represent myself, then it's going to be a new trial for failure to, like, ineffective, some remanded back. That when I said get through the first trial, it's so that if post-trial, you know, post-conviction sends it back for a new trial, or there's an order under 20 or whatever the rule, you know, for new trial, you know, by you know what I'm saying? When I said a new trial, I didn't mean sever. No, I mean, I want them all in one, consolidated, but I don't know how that affects him being, you know, doing the special action.
Yeah, it's like,
So it seems to me that I don't want to set a trial date today where we have two separate trials, because it may be that everyone wants them consolidated. You want Mr. Parvin to continue to represent you
Right,
to do
for the special action, right?
So maybe if we set the pre-trial conference out for a while, and then maybe this will get to a point where you.
But there is a July 21st target, right?
It's on the calendar.
That's what I'm saying. So that's why, because that's what I brought up. I said, well, how could, you know, it's hard to, under Rule 8, you can't just, you gotta have extenuating, so, you know what I'm saying? Under Rule 8, you can't just be like, all right, we're gonna, you know,
may I say something?
but he said that it can be brought sooner without violating.
I'm gonna clarify the situation. Your Honor, I can tell you my forte is motions and appeals. I enjoy doing it. I'm proud of my motions. I think it's gonna be a great motion for appeal. That's what I'm focused on. I think that's the heart of this issue. Mr. Myers informed me that in the event we can't do motions, he wants to do the jury trial himself, and he has every right. He's also does some training, paralegal training. He knows he's done trials himself. He's confident. He wants to do this if need be. I don't want really a speedy trial. Mr. Myers does. But hold on, I'm not explaining. I want to focus on this. This needs to be handled by the Court of Appeals and the Arizona Supreme Court. But obviously, in the free for all, I have no idea what's going to happen. But what do we have to lose? That's why the argument is, if Mr. Myers wants to be on this case, if this court wants you to remain on this case, grant the constitutional basis I gave you for release conditions, and we appeal out of custody. And again, offer the most stringent conditions possible and warn Mr. Myers that if you mess up even one time, you're back in there pending the whole appeal. And that's why I'm on the case. We'll do this without a mess of trial, without all these things you heard. That's the fair thing to do, Your Honor. I will end with that. But again, does that make sense?
Can I add something to that? I wanted to say that the reason I want a fast and speedy trial is because I'm sitting in jail with no bond.
Yeah.
You know what I'm saying? So if I'm out on bond, we can take 2 years. You know what I mean? She can have her little settlements and all this kind of stuff. That
the appeals court can get it right.
If I'm sitting in jail with no bond, I want it as fast as possible.
So let's reset this. How about, when is your trial over? Or when would you have time during your trial? What's like the dark day for whoever's trying to case?
So his dark days are Mondays.
Okay, so,
Next Monday. Next
how
month.
about we could do like Monday, May 19th? Monday, May 12th, I have a lot already, and I know for some reason.
That's a
I have
month.
on that day, I don't know why. I just think someone else.
It's a long time.
But the 19th,
So I have, just to be clear, so it's this week and next week that I'm in trial. After that, I'd be open to other dates as well. So it doesn't have to
That
be.
hampers me
Hold on.
filing like the remand and stuff, because that's gonna exclude.
Well, we're clarifying. You might, again,
I can put all that stuff.
we'll get a ruling on whether the court's going to consider my argument of why we can special action out of custody, Mr. Myers.
Yes.
Okay, because we don't want to wait till May 19th for that. I got to get started on that.
You're saying the bond hearing will be May 19th?
No. In the event,
We're just gonna have a pre-trial conference.
Oh, okay.
Clear out those issues. About whether. How about Monday, May 5th? Would that work?
That would be fine.
How about Monday, May 5th? Would that work?
and to clarify, will that be, if the court agrees that I should get an opportunity to argue on whatever standard this knowingly means, either a hearing or if the court agrees constitutionally, we should be able to appeal, will that be addressed before that point or on that day?
I'm first of all, I'm gonna do the research and try to come up with an answer with that. And on the 5th, we're gonna talk about the status of the case, whether to set 2 separate trials, whether to have a bond hearing. I just gonna have it kind of open-ended based on the way things go.
I guess Mr. Maya's concern is we do want a special action. I don't think there's any, I know there's 14 days to, actually, I think it's more felony, because there's more, whatever, there's a time limit of when you can appeal a ruling. I know special action doesn't have a time limit, but they do consider the appellate time limit. So when you just start the special action, I'm just making a record that the court's giving the Court of Appeals basically a reason why I'm waiting. That's my concern is.
Yeah. I haven't ruled on the motion for bond hearing yet, which is wrapped up with your First Amendment issue.
Okay, so that would be, and if the court, let's see, well, okay, as mentioned about legal resource, well, we'll get to legal resource, this is all part of it. Someone's bringing up about the legal
Well, I mean,
resources.
I can't just sit in the jail and suck on my thumb right now. I got
Hold
some other things that we need.
I know, but we're getting, listen, Mr. Myers, I think we made a powerful
We're out
argument.
of time.
I'm hoping that the court is consider why you should be released depending on this constitutional
I
issue.
agree with that, but I still need to work the case and, my case as.
We've run out of time, Mr. Myers.
Can you please do something about the disclosure? That's all I just wanted, because this is supposed
But
to.
let me set the hearing first. Monday, May 5th at 3 p.m. for 1 hour or an hour and a half. We'll just set it for an hour and a half. That works for everybody?
Yes, and then that's gonna be a determination of whether we get a rehearing or that will be the rehearing. So I'm trying to.
Whether you get a rehearing and whether we set the cases for trial together or separately. I think we just need to address everything that we've raised today.
All right, but we could, if the court agrees, and we might be able to do a hearing that day or discuss release conditions. I'm not saying the court has to, but if the.
Yeah, we can
We
address
don't want
that.
to do another 2 weeks after that, that's what we're saying.
And Your Honor, it sounds like Mr. Myers has some issue with disclosure, so if we could try to address that. I don't know what his issue is. That's what I want to.
So I'm gonna do, so in the first case, it'll be pretrial conference and status conference. In the second case, it'll be a status conference on May 5th. Okay, Mr. Myers, what's your
Do you have
disclosure?
their, list, they submitted state's potential list?
No, I haven't looked at that.
You have it up there?
Is it filed or just filed with the simply have?
Filed.
Yeah, so it's the state's notice of witnesses and
List of
exhibits.
potential witnesses and exhibits, it should be filed. Hold on the 15th. Okay. This is very important.
Gonna file it, April 15th.
So it says,
Oh, here we go. All right.
okay, I have it up. All right, thank you. So 15.1B1, name, address, and any relevant written or recorded statement. This is boilerplate trash right here. This doesn't come anywhere near meeting the rules disclosure. It says there, it doesn't even say their name, address, and any relevant recorded statements for the witnesses. And then it says under their submits, their exhibits, any and all, and you know, you've been around the block a long time. You're anytime they start the statement with any and all, any and all, any and all, boilerplate trash. So here's the deal. Under 15.51, 15.1B5, list intend to use it.
Thank you, David.
Any and all photographs. They
you,
talk about
Temper.
Matt Catchman photos, they talk
Appreciate
about
it.
my baby photos, they talk about photographs. They need to list out all the photographs they had, and they can say, we'll use any or all of these photographs that we have in this list. Then they're gonna list, they need to list out witness statements, and then they can say, oh, we'll use this witness statement or not. But they need to say the witness statements they have, the police reports they have, the statements they have, the YouTube videos they have, the property they have, the body worn camera, any and all body worn camera. How would I even know what body worn camera they have if they don't list it?
Mr. This is a very complicated issue, actually. We're gonna address this.
This is all the more reason why I think the court should grant our request to appeal out of custody, Your Honor, because this will all be moot when we do this.
But I have a deadline to respond to them, and I have.
That can be extended, that can be extended.
Can you extend my rule, you know, how I gotta respond within 10 days of theirs? Well, I feel like I'm gonna file a Brady motion in the next couple of days because I need this exculpatory evidence. Where's in number 8? Where's Shannon's loyalty oath? Why haven't you given it to me yet?
So that is not a motion that he has to respond to, so he
No,
doesn't have a.
hold on. I have to file mine within 10 days of them
Between you
filing
and
next
Mr.
month.
Myers, he may agree to get out next time based on this issue.
I have to work the case.
Hold on. We're gonna address this on the 5th.
I can't 15 stuff, the rule 15 stuff,
Yeah, we can address the Rule 15 things on the 5th as
because,
well.
because I need to.
We're running out of time, Mr. Myers. It's a complicated issue.
It
I
is.
can't resolve it today.
Mr. Myers, remember, if we get appeal out of custody, you don't have to worry about this.
Can you grant me an extension to file my rule 15.2 B and C then? That's what I'm trying to say. I have to, I have 10 days to file mine when they filed. So I have 10 days to respond to this with my list. And I'm saying that's 3 days from now. So what I'm saying is I either need an extension to file mine, or they could say, oh, you can't use any of that because you didn't file it in time.
So, Your Honor, the state's Rule 15 initial disclosure was sent out with the initial discovery. This is just the further, because he asked for a more specific list, and so we sent him a more specific
This is not
list.
specific.
It's all the disclosure, we sent him all the disclosure. He's already filed his 15-2, so he's not in violation.
Okay,
He sent me a 15-2, so he's not,
Beginning, I'm gonna amend it.
what I can say is he's not in violation of anything. If for some reason there's some deadline, we would agree to extend it, so he's not going to be in violation of anything.
It's 10 days from theirs.
And I need to join in that as well, because I wasn't sure if he's representing himself or not at trial. If there's gonna be a trial, I have not filed a separate 15-2, but it would be joining Mr. Myers 15-2.
so noted. All right, we'll see you back here on May 5th.
Well, we gotta get through, look, I want to go to the appeal.
I need their witness list.
Well, that sounds like it was it. What do you guys think?
Interesting.
Keeping an innocent man in jail, disgusting. I agree with you, Modern Retro Radio. The interesting thing was, for me at the end, is the judge was all hurry up and let's get out of here because it's time to get off work and go home and get some nice hot dinner. No humanity at all, thinking about somebody else that's going to go back to a jail cell for BS reasons. But
All right, so guys, I'm glad you guys joined me. That was Reluctant Prophet. I definitely invite you guys all over to join him and like and subscribe to his channel. I'm going to go ahead really quickly and say thanks for Gloria Ad, Pavesti, Chevy, Kurt Bronson, all the usual suspects for showing up today. Today, I'm going to go over the actually opening brief that his lawyer did for him, that Lane's lawyer did for him, as well as the opposition done by the attorney, and then explain to you from my perspective as a California and Texas lawyer Unfortunately, I'm not licensed to practice law in Arizona, so I can only give you my perspective as if this was in my state. But since a lot of this has to do with constitutional issues, we should be able to have a good time and pin down some stuff. I'll try to get you through it quickly. I know a lot of you guys. Yes, Pavesti, I am a lawyer. I've been practicing law for about 20 years. I primarily do catastrophic injury cases like major car and truck accidents, airplane accidents, and cruise ship law. I'm a co-author of the original Cruise Ship Safety Act that was passed by Congress years ago. I think it was 2010, and I've lobbied on behalf of victims in Congress, and now I just do a lot of PI work, and I sometimes come on YouTube just for fun, just to unwind and try to share what I know with people, because so many of you make so many mistakes, and I don't want you to end up in jail like where Lane is now. So I want to sort of give you the rundown on what to do and what not to do to keep your butts out of jail and out of criminal confinement, because it's just no place for anybody to be. And so the first thing I'm going to do is just kick off my show with my regular little bumper, and then I'll get into explaining to you the different constitutional challenges that can be made and the facts of Lane's case.
To another edition of Ask Michael Ehline. This is where I teach people the law in an unorthodox manner by using examples that we see in the news, case law briefs, but it's all about exposing the Leviathan and its instrumentalities and taking back your rights. Know the law and mean to keep it well. Come here to learn from an expert to know your right. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel.
That's right. We never know when the thought police are going to take down this channel. That is for sure. So really quickly, what we have here is Lane's lawyer is making a challenge to a statute, a harassment statute, and he's making some of the arguments that I originally told you guys about when I first started covering this, about why I thought this statute was ridiculous. And I argued that it should be facially challenged and challenged as applied and challenged for vagueness. So I'll just really quickly go over the different ways you can challenge a statute when you're being prosecuted and you want to go up on appeal. One is to make a facial challenge, and that's where you just assert that the statute is unconstitutional or invalid in all of its possible applications, and you just argue there's no set of circumstances under this statute for which the statute could ever be valid. And you want to argue that it's overly broad, that it's difficult to succeed, because the challenger has to show the statute is unconstitutional in every conceivable situation. That's the problem with it. So facial challenges are very difficult. The other one is as applied. As applied just means that as applied to this particular case or this person, that this statute's no good. The person charged under a vague statute could argue that as applied, it can't apply to them for whatever reason. Another one will be the vagueness challenge, which I think is a strong argument here, which we'll get into in a minute, which simply means statute can be challenged for being unconstitutionally vague if its language is so unclear that it fails to provide fair notice of what conduct is prohibited, and that allows arbitrary enforcement. And obviously in this case, harassment to someone in Nazi Germany is going to be a lot different to someone who's an old school Second Amendment rights advocate like me who might live in Arizona. Harassment to a U.S. Marine is going to be a lot different to one of these safe space college grads that just got out of Berkeley and is used to calling anything hate speech that's not far left commie. So that is a problem. The other one will be the overbroad, that the statute's overbroad. If it prohibits constitutionally protected conduct in addition to unprotected conduct. And here the statute doesn't even give Lane an out to argue that he was exercising free speech, because this woman who he was allegedly harassing is also a government official. And he's not even allowed to make those arguments under the statute. So overly broad. Equal protection, he could argue that it discriminates against a protected class. I don't know that he would be able to apply. He would be able to that would fly in his case. And he can also argue substantive due process, that it infringes on fundamental rights or liberties without a compelling governmental interest. And I would argue in this case that substantively it prevents Lane Myers from petitioning the government. So that's one of the arguments I would make. There's also a procedural due process challenge. The statute, and I would argue that procedurally it's depriving him of due process because he's being forced to be locked up under a statute that's not very clear and that's already being looked at by the Arizona State Legislature as being a bad statute that should have never been passed. And that's something we're going to get into in a minute. Could also argue the supremacy clause, that it's preempted by federal law and that the state statute violates federal law and that the federal law is supreme here. Sometimes you can argue commerce clause. I don't think that would fly here. Statutory interpretation challenge, which I think you could make here. As applied challenges typically are going to be narrower, focusing only on the statute's application to the challenger's circumstances. And so I think that's probably where his lawyer is going to go, probably on this one, is on the as applied. And I haven't even had a chance to read all his briefs. Oh my gosh, thank you so much. Niram sounds very Scandinavian, says, don't people go to jail for violating protective orders, including harassment in domestic cases? Well, sure. I mean, if the protective order was valid on its face, but if it was an unconstitutional protective order, it wouldn't. And I believe that in this particular case, Lane has a pretty good argument that this harassment statute is unconstitutional and also statutorily unenforceable. And we're going to talk about that in a minute. But yeah, I mean, sure. Anybody who breaks the law and violates something in a criminal case is always potentially going to be subject to some kind of jail or something. Sure. Okay, so really quickly, you guys have a real treat coming for you. Hopefully you can see this. I'm going to try to blow it up a little bit more. This is the actual, I was actually fortunate enough to get my hands on William J. Parvin Esquire's brief. So this is the actual brief that he filed in the court. It's called a motion to dismiss aggravated harassment counts on grounds of vagueness, overbroad, and First Amendment. So there you go. And you heard the prosecutor really upset that he was trying to argue First Amendment. But I think that Attorney Parvin has a pretty good First Amendment challenge because in its application, the statute is restricting Lane Meyer's free speech to petition the government, in this case, a government employee who happens to be married to a prosecutor in a case that he was involved in. So basically, he moved to dismiss the aggravated harassment charges, counts 1 and 2, because the statute currently in effect is vague, overbroad, and violates the First Amendment. Now, the Arizona Court of Appeals previously ruled the harassment statute under ARS Section 13-2921 was constitutional in State versus Brown. And that ruling involved an older version of the statute, though, and that's the problem. So hopefully you guys are following me. So this particular statute, although the code section is the same, the statute was different. There were defenses available, like being able to argue you had a First Amendment right to petition the government, which would take you outside the statute. And that's not being given to Lane here. Really, oh, hey, Chevy, thank you, brother. Chevy says for Nairam Nalmud. Yeah, good question. Yeah, Chevy's thanking you, Nairam Nalmud, for your comment and for your question. And I thank you too, because there's no such thing as a stupid question. There's only such thing as being stupid for not asking a question. Because if you don't know, you don't know. And you got to learn if you want to know your rights. And that's what I'm here to try to do, is to help you guys out today. And, you know, look, I get it wrong all the time. So I'm not trying to tell you that I'm like a genius or anything. But at least I've got 20 years in and I know a little something. You know what I mean? All right. So although the Arizona Court of Appeals ruled that this particular statute was constitutional in the State versus Brown case, that ruling involved an older version of the statute that's no longer in effect. And as a result, so here's what happened. In 2022, the legislature modified this statute by moving a requirement of intent. Okay, and that's very, like in California, our statutes are drafted that way, that you have to show intent. You intended to harass, not just that you harassed and the person felt harassed. That is something that's something that would happen in Germany or the United Kingdom, right? Where they flood their country with illegal alien criminals and jihadists. And if you say anything bad about it, the government throws you in prison. Even though you never really intended to harm those people, those illegals your government flooded your country with, who hate you and your way of life. You don't even have to. The government doesn't require you to show that you intended to harm anyone. Just the fact that you made the statement would have been enough, and that's basically what Arizona and a lot of the leftist legislatures are doing now. They're trying to characterize anything they disagree with politically as hate speech, and so the legislature modified the rule to remove the requirement of intent. So there you go. That's why you don't want to live in a blue state, guys. So there is no decision by the Arizona Court of Appeals upholding the current statute. And I know you're going to say that Arizona is red, but these districts and the legislatures that pass these laws are overwhelmingly leftists, even if it is a so-called red state. Let's face it, all the people fled California who didn't like all the laws that they voted for and the high taxes that they voted for and came to Arizona so they could destroy your state. They're basically like the Borg from Star Trek. Give me a bunch of ones if you agree. Anyways, later on, the legislature appeared to acknowledge the mistake they made. Yeah, right. So in HB 2043, they are now trying to pass a law where it will once again require intent. So they're trying to put the requirement of intent back into that statute, which right now the prosecutor's sitting pretty. And that's why the defense attorney, Parvin, was saying, look, under this statute, my client's guilty because I can't argue any defenses like he had no intent, right? So that's a problem. Basically, the statute's drafted in such a way to where you're guilty until proven guilty. That's really what it is. You're guilty till proven guilty under this statute. So this new bill will make it clear that there is a defense available if the act is directed towards a public officer or employee and it constitutes criticism. Are you following me so far? And I think that that's why the judge was a little circumspect, and probably I felt like the judge was going to rule in favor of Parvin, but he also has to be careful, because if he does that laying out, and hypothetically Lane did hurt someone, it could ruin his career as a judge. And so that's one of the problems that these judges have. Okay, hopefully you guys are following me so far. So the current legislature is correct in believing they made a mistake. I agree with Parvin. I think that he is right on the money. And although it's easy to be an armchair general and criticize him and say all these negative things about him, I learned a long time ago being an armchair general doesn't win cases. And so I'm giving Mr. Parvin the benefit of the doubt here. And based on reading his brief, I think that he did a superior job. And I think that the court should have granted this today. Now, to protect the right of free speech is what the court has to rule on in this statute, and that's why it's unconstitutional. And now let's get into the memorandum of points and authority. So I'm not going to keep on like highlighting everything, but I'm just going to read this to you quickly, privates, to get you through it. So these are the facts of the case through the eyes of Lane Myers, defense attorney. Mr. Myers maintains a YouTube channel for nonviolent social change. He also has a registered company called Freedom Productions LLC and is an investigative journalist. Although Mr. Myers' methods may be unorthodox, he has a growing list of subscribers, now totaling more than 15,000. Originally on June 4th, 2024, Mr. Myers was arrested for booing at a Tucson City Council meeting and prosecuted in the Tucson City Court. I mean, you can't make this stuff up, guys. This is like something out of like 1920s Germany or modern United Kingdom, right? Anything that goes against the jihadis they flooded their country with, you go to jail for. Same kind of crap. The assigned prosecutor was Matthew Walker. Mr. Myers broadcasted his court proceedings on his YouTube channel, audio recorded them. He also made videos discussing the case and his interactions with Mr. Matthew Walker. Shannon Walker is a public employee who works at the University of Arizona. She was the director of special projects and the right hand of the dean, and later the director of alumni and development. Her name, work phone number, and work email are all publicly made available online. On September 12, 2024, Mr. Myers left a voicemail on Miss Walker's work phone inquiring into his prosecution by Matthew Walker. Mistaken or not, Mr. Myers believed there was a connection and wanted to investigate. Ms. Walker obtained a civil judgment against harassment on Mr. Myers pursuant to ARS Section 12-809, which was served on Mr. Myers on October 17th, 2024, and upheld on November 14th, 2024. Mr. Myers was in the process of appealing. While in the process of contesting the injunction, Mr. Myers posted a YouTube video explaining his self-defense and interpretation of the law. Although Shannon Walker was mentioned because she was a party to the case, no private information was ever revealed by Mr. Myers. Mr. Myers never sent videos to Ms. Walker. Mr. Myers only explained the process of obtaining public information and how anyone could contact Ms. Walker in her capacity as an employee of the University of Arizona. That's all he did. Although Mr. Myers never contacted Ms. Walker and has never encouraged any sort of violence or threats, sadly, a few awful people who should be prosecuted to the full extent of the law wrote disturbing emails and left voicemails to Ms. Walker. Mr. Myers believes his competitors and those who want to harm Mr. Myers may be responsible for those messages. Well, no, duh. I can think of about 10 people off the top of my head who probably are the ones who did this because they wanted to get Lane in trouble. People who don't like Lane probably did this, probably made sure that he would get locked up because they knew that the judge would throw the book at him. Anyways, the state indicted Mr. Myers on charges of aggravated harassment, among others, and Mr. Myers was arraigned on March 14th, 2025. Mr. Myers has adamantly denied any wrongdoing and claims he is exercising his First Amendment right of free speech. Mr. Myers maintains he had a legitimate purpose under the law. Mr. Myers believes his conduct is protected and legal under the law. For this reason, he has not stopped his alleged course of conduct after the hearing, but before the minute entry finalized the terms on March 17, 2025, Mr. Myers posted a video explaining his defense. Mr. Myers explained the injunction and why he believes it to be lawful. No private or confidential information was revealed. Additionally, Mr. Myers posted a video showing public information on websites labeled, "Is this a felony?" The video showed the public employment information of various employees at the University of Arizona, including Shannon Walker. On March 28th, Mr. Myers was indicted on 2 counts of aggravated harassment under ARS 13-2901.01. Although Mr. Myers is not an attorney, he makes every attempt to educate himself on the law as it relates to his YouTube and journalism activities. Mr. Myers reviews statutes and case law on a daily basis. He educates others on the law through his YouTube channel. Mr. Myers has inspired his viewers to stand up for and educate themselves on their legal rights. Some have even applied to law school. Mr. Myers has a history of walking a fine line in his efforts to exercise his First Amendment rights and promote social justice. Mr. Myers depends on clear and unambiguous definitions in statutes, so he knows precisely what he can and cannot do beyond a reasonable doubt. This motion to dismiss now follows. All right. So hopefully you guys are getting this so far. So Nyan Almold says, I looked into this a few months ago and saw him. Yes. Yeah, this is pretty amazing stuff, man. You know, I would take the sunglasses off, Michael, but I've got a really bad eye infection, brother, and I'm hurting. So, and unfortunately, I've got these studio lights so you guys can see me, and I look decent for you. But I agree, they look pretty terrible. Next time, Michael. So I'm just looking at your comments here. Thanks again, guys. I'm going to see if anybody threw me any super chats or anything like that. Oh, Gloria, thank you so much. I always got to look, guys. Thank you so much, Gloria. Gloria Ad says, keep up the good work. Well, I appreciate that. Everybody give me a bunch of ones for Gloria for supporting Team MPE. I really appreciate that a lot. All right, so let's keep going. Good seeing you, Jody Shiloh. All right, so let's get into the arguments now. So the arguments that he's making is the legislature's conflicting definitions and defenses to harassment commingled in the statute renders the aggravated harassment statute void for vagueness as related to Mr. Myers. A statute is void for vagueness if it is not defined in ordinary terms that people of average intelligence can understand it. And that's State versus Varela, 120 Arizona, 596 to 599 to 587 P2D 1173, and that's a 1978 case. And it looks like he's doing his citations under the Blue Book style manual. I use the California style manual where we put the date right after the party names. But still works. No one should be required at the risk of his liberty to speculate on the meaning of a penal statute. When men of common intelligence must guess as to the meaning of the statute and differ as to its application, due process is violated. And that's a U.S. Supreme Court case called Connolly versus General Construction, 269 U.S. 385. It's a 1926 case. Hopefully you guys are following along so far. Give me a bunch of ones if you understand so far. The court must give every effect to every provision of the statute. Mijak v. Granville, that's at 212, Arizona 555. It's 136 P3rd, 874, 876. And that's a 2006 case. It must be interpreted so no provision is rendered meaningless, insignificant, or void. The statute is unconstitutionally vague if it allows for arbitrary enforcement, which I think obviously is what happened here. State versus Brown, 207, Arizona, 231, paragraph 16, 85, P3rd, 109, 115, App 2004. So that means it's a Court of Appeals case, I believe. Again, I'm not an Arizona lawyer, so the citation's a little bit different than what I'm used to. Aggravated harassment under section 13-292-101 requires a valid injunction under section 12-1809 and a conviction for harassment under 13-2921. ARS section 12-1809 T sub A defines harassment. And this is what I think is unbelievable. A series of acts over any period of time that is directed at a specific person that would cause a reasonable person to be seriously annoyed or harassed at conduct, seriously annoys or harasses the person and serves no legitimate purpose. Well, obviously, let's just keep going. Harassment under section 13-2916 sub E sub 3 defines it as knowing and willful course of conduct that is directed at a specific person that would consider it seriously alarming, seriously disruptive, tormenting, blah, 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 blah. Now, it does not apply to constitutionally protected speech or activity or to any other activity authorized by law. The related crime of stalking under section 13-2923 provides a defense to causing a communication if there's a legitimate purpose. So what he's doing is he's showing you other statutes that require intent and comparing it to this one that simply says if a reasonable person, like somebody who gets twisted panties, feels harassed, you don't have any defenses, even if they're a public official, right? Even if you had a legitimate purpose under the First Amendment, that wouldn't apply here. In other words, you're guilty until proven guilty. That's basically how this Arizona statute reads, and that is why the Arizona State Legislature is in the process of reframing the statute. But who does it help? Well, it helps the prosecutor. And I think that the judge is intelligent enough to know that this statute should not be used against Lane. It's unfair. And I'm thinking, just based on the demeanor of the judge, that he sort of had to take it under submission, because after all, there's a lot of politics in the courtroom. It's not just about the law. You got to see these prosecutors again. These are the people that are going to support you when you run for office, run for judge, or the people who are going to talk trash on you and try to hurt your chances at getting reappointed by the governor, if that's what's going on. So it's a problem. They'll blanket paper you, so they never have any cases in your court. So there's a lot of things that go on in the court politically that a lot of you guys just don't know about. Anyways, so stalking, so it basically says it does not apply to constitutionally protected activity or other activity authorized by the law. Otherwise, probably he would have been charged with these other statutes. So harassment under section 2921E is defined as conduct that is directed at a specific person that would cause a reasonable person to be seriously alarmed, annoyed, humiliated, or mentally distressed. And the conduct, in fact, does that. And the phrase causes a communication is not defined. Okay. So that's a problem. This is something that I didn't think of when I was doing my armchair generaling on YouTube. Parvin has a great argument here. Look, causes a communication. That means that if I just post something on YouTube about Lane Myers and it's negative about these government public employees, that would be enough to get Lane thrown in jail, unfortunately. And sounds like that's what happened here. Because obviously, did Lane cause me to do a YouTube video? Well, not necessarily. But the story about Lane Myers and what happened to him definitely wants me to talk about it and talk about how unfair it is. And if I haphazardly mention the so-called victim and the fact that they're all government employees on taxpayer dollars and that he's trying to complain about them, that might be enough to get him thrown in jail under the statute. There's no defense for having a legitimate purpose. There's no defense for having a legitimate purpose. So obviously, if this went to the U.S. Supremes, this case, in my opinion, this statute would be stricken down in 2.5 seconds. It wouldn't even take that long, because it's obvious that this is unconstitutional as applied to Lane and just the whole vagueness part of the statute. There's no defense at all for constitutionally protected activities at all, none. The only exceptions are lawful demonstration, assembly, or picketing. Social media is not protected, nor is it defined. So online activities are not protected. Every other type of speech, except for the 3 specific activities listed above, can be prosecuted as harassment in violation of the First Amendment. And that's why I felt that the prosecutor's arguments were pretty disingenuous when she kept on bringing up that there's no First Amendment. He's not allowed to make a First Amendment argument here. Because sure he is. He's being denied a defense that the law should allow him. And that's allowed under all the other statutes except for this one that she cherry-picked to charge him with. She cherry-picked this statute because she knew that he wouldn't have any defenses, which I think is really terrible for a prosecutor. See, I believe when I worked for the prosecutor's office in LA, my supervisor told me that our job isn't to get convictions. Our job is to do justice. Remember that. Our job is to do justice as prosecutors, not just get convictions. She's just looking for a conviction, in my opinion. Otherwise, she would have charged him with a statute that was just. She clearly should have been able to see that this statute is unjust, totally unjust. And obviously it was written in such a way that guaranteed that Lane would get the golden handcuffs put on him. So Mr. Myers depends on well-written, clearly defined statutes in his quest for social justice and to ensure everyone's First Amendment rights are protected. Some may not agree with Mr. Myers' methods, but nonetheless, Mr. Myers depends on these statutes. Mr. Myers is now being prosecuted for felonies due to vagueness. As the video submitted at the bond hearing showed, Mr. Myers was explaining his defense on appeal for the injunction against harassment under Section 12-809. He was explaining his defense to charges and why he believed he was innocent. Mr. Myers asserts he had the legitimate purpose of criticizing the work of Shannon Walker as a public employee and identifying alleged government corruption. Mr. Myers made it well known it was not his intent to harass anyone. Mr. Myers posted a video about how to find publicly available phone numbers and emails online. The videos were made to educate his viewers. Mr. Myers often showed the civil and electronic definitions of harassment. They require there to be no legitimate purpose and that the conduct does not include constitutionally protected activity. He explained why he believed his current conduct is not harassment under the law using these definitions. These videos show Mr. Myers intended to conform his conduct to the law rather than harass. Bravo, Mr. Parvin. That is an eloquent and very proper argument. Mr. Myers welcomes the opportunity to tell his story to the jury. The problem is he could be found guilty as charged under this unconstitutionally vague statute. The statute does not allow Mr. Myers to assert he had a legitimate purpose. It does not allow him to assert that he was criticizing Ms. Walker in her capacity as a public employee, despite the constitutionally protected constitutionality of such criticism. He was not picketing, creating a demonstration, or engaged in assembly. Mr. Myers was using social media. Social media is protected under other definitions of harassment, but not under Section 13-2921, which obviously is why she brought it, right, guys? Give me a bunch of ones if you agree that she cherry-picked this statute because she knew that he would have no defenses available. Come on, guys. It doesn't take a rocket scientist to figure out what's going on here. Hello, Star Chamber. Mr. Myers is not permitted to explain that he had no intent to harass Ms. Walker. Intent is not required under the current statute. Even the legislature in Arizona is right now today aware of this problem. And that's why they're in the process of overturning that statute and recrafting it to where it will be constitutional, because I think they realize it's not constitutional. They realized that it was a mistake and that they created an unconstitutional statute. They're in the process of fixing it, by passing HB 2043. Until then, this court must rule that the statute is vague. Absolutely, I agree with that. And I think the judge also knows that. A person of ordinary intelligence would not understand what is and is not protected activity under the current version of the statute. With such vague terms, the state can arbitrarily decide who to prosecute because the intent of the individual has no bearing on the case. Anytime a public employee is annoyed or gets their feelings hurt over criticism, they could claim harassment and demand prosecution. This is an unacceptable application of the harassment law. And I believe that Mr. Parvin is right, that the court must render this it vague. And if they render it vague, it must be rendered unenforceable. The legislature's removal of the requirement of intent rendered the statute impermissibly vague as applied to Mr. Myers. So here's the as applied portion that comes in. The Arizona courts upheld the harassment statute as constitutional originally under State versus Brown because it required specific intent. With the requirement of specific intent, there was no fear that people would be criminally punished or for protected speech under the previously approved harassment statute. A person would not be prosecuted for criticizing government employees, delivering bad news, or otherwise exercising the right to free speech because the state needed to prove the specific intent to harass. There is no categorical harassment exception to the First Amendment free speech clause. And that's why I was sort of giggling inside at the prosecutor trying to argue that Lane's not allowed to argue free speech in this case. Free speech isn't at issue. But no, it absolutely is at issue because it would be probably the only defense that would be available under the statute. It would be a defense under the statute as it had been originally written, but the legislature changed it to remove that intent requirement, and that's why the prosecutor selectively used it to prosecute Lane. And to me, a good prosecutor would try to do justice and not just try to throw the guy in prison using a statute they clearly should know, if they're a reasonably intelligent prosecutor, is unenforceable as a matter of law. There is no categorical harassment exception to the First Amendment's free speech clause. That's Rodriguez versus Maricopa County Community College District, 605 F3rd, 703, 708, 9th Circuit. So it's a 9th Circuit case. I haven't shepherdized it, but it's a 2010 case, and I'm pretty sure it's mandatory authority. I don't think that Mr. Parvin would cite a depublished case. Okay, so hopefully Mr. Parvin's watching. I'm being super fair with him. I'm not going to sit here and armchair general the guy. So far, I think he's done a great job in this motion. As discussed above, Arizona's current harassment statute does not require intent to harass. ARS Section 13-2921. There is no current exception for criticism. There is no exception for social media. A person can be prosecuted for delivering bad news or critiquing others, including public employees. There is no definition for what the phrase cause a communication with another person means anywhere in the chapter. Without a requirement of intent, this phrasing in Section 13-2921 sub E is unconstitutional. Though people may disagree with his methods, Mr. Myers had no intent to harass Ms. Walker. His purpose was to investigate potential government corruption, even if it turned out there was none. His purpose was to defend himself in the court of public opinion. Give me a bunch of ones if you agree, because I do agree with that. And explain how he was not violating the law. Sadly, due to the vagueness terms for harassment under Section 13-2921, the state can prosecute Mr. Myers under a theory that requires no intent and does not permit his constitutional defenses. The legislature is working on a fix for this unconstitutional dilemma with HB 2043, but until it becomes law, Mr. Myers is at the mercy of the court to declare the current version of the statute unconstitutionally vague. The current harassment, this is argument C, the current harassment statute under Section 13-2921 is overbroad. The statute is overbroad in a violation of the First Amendment if it is designed to punish activities which are not constitutionally protected, but includes within its scope activities that are. And obviously, clearly, having a YouTube channel and posting stuff about this public servant would be normally protected activities. And that's State versus Brown, 207 Arizona, Section 231. Distributing public information to third parties is constitutionally protected. Schneider versus State, 308 U.S. 147. That's a U.S. Supreme Court case. By the way, just so you guys know, anytime you see like 308 US, anytime you see this US right here, that means it's US Supreme Court. So that's going to be the supreme law that all courts have to abide by. The distributor of such information may not be held liable. Social media is protected under the First Amendment. Packingham versus North Carolina. It's another one, 137 Supreme Court. That's just another way of citing it. You can cite it. Well, anyways, we'll get into it another time. Looks like this is, well, I'll talk about citations later. Okay. Prosecution of speech that inspires others to take lawful action is unconstitutional. Again, prosecution of speech that inspires others to take lawful action is unconstitutional. See Organization for a Better Austin versus O'Keefe, another Supreme Court case, 415 U.S. 415, 419 to 420. The claim that expressions are intended cause a coercive impact on respondents does not remove them from the reach of the First Amendment. The court in Brown previously ruled ARS 13-2921 regulated conduct and not speech because it required the specific intent to harass and was based on the underlying purpose of the communication. As discussed above, this is no longer the case since the legislature removed the requirement of intent. Now anyone can be prosecuted for giving a bad review online. One can be prosecuted for criticizing a politician online. And the state can selectively choose which public figures they want to protect with selective, arbitrary prosecution because intent is not required. The reason Mr. Myers is being prosecuted here is because third parties are contacting Ms. Walker on her publicly available work email and work number. There's no questions that some of these things these third parties are saying and doing is despicable and not protected free speech. The harassment statute very clearly was meant to prohibit that type of conduct, but Mr. Myers is being prosecuted due to the success and reach of his YouTube channel. The state is prosecuting Mr. Myers' exercise of the First Amendment to criticize public employees and post public information. This sounds like something out of like communist China or like Germany, right? Right, guys? Or like the United Kingdom, right? How they're just throwing people in jail for making Facebook posts. They're trying to normalize this in Arizona. The state is taking the advantage of the current statute's overbreadth, which does not require intent. Under the current statute, Mr. Myers' purpose is irrelevant. This is particularly problematic because Mr. Myers was clearly and explicitly discussing public records, public events, the law, legal cases, and the actions of government actors he disagreed with. The state's theory of the case is that Mr. Myers caused a communication to Ms. Walker simply because he talked about the injunction of his YouTube and posted how easy it is to access government employees' publicly available work information. Never mind the fact Mr. Myers did not directly or even indirectly contact Ms. Walker in the videos. The state's theory shows the harassment law is unconstitutionally overbroad. It is understandable that Ms. Walker has been harmed. It is understandable that Ms. Walker has been harmed. Those responsible for any harmful or illegal messages should be prosecuted under the full extent of the law. However, the state is wrongfully using Mr. Myers as a scapegoat here under the theory that is impermissibly overbroad and violates the First Amendment. The court must dismiss the charges. And then he talks about, how the charges should be dismissed. And let me see if I can blow this. So, and I also was able to obtain from Reluctant Prophet a copy of Laura Conover's response to the motion to dismiss the aggravated harassment counts on the grounds of vagueness and overbreadth. And I'll get into that. I may get into that in another video, guys, because I'm getting kind of burned out. But I just want you guys to see what's going on here, and I want to be able to answer any questions. But I'll just really quickly, I'll gloss over them just for the heck of it, just for the heck of it, right? Okay, so basically, she's saying that after he got served an injunction, he kept on going on YouTube and making videos, posting about Miss Walker, spreading misinformation and posting contact information, posting publicly available contact information. And then this thing about spreading misinformation, I mean, that would have to be a finding that's made by a court you could file a motion for findings of fact or conclusions of law, or by a jury. So I think she's impermissibly just adding things, embellishing and embroidering. Not a good look for a prosecutor, to be honest. Assuming facts not in evidence. I mean, you'd think someone who took a basic evidence class would know not to put stuff like that in there. Basically, guilty until proven innocent, right? Or in this case, under this statute, guilty until proven guilty, because there's no intent requirement. So anyway, she's saying a hearing was held. Mr. Myers contested the injunction at the hearing. Mr. Myers heard evidence that other people were leaving threatening and harassing messages. Basically, she's just admitting what his defense attorney is saying, is that other people did it, not him. And then the injunction was upheld but modified, that prevented Myers from having direct or indirect contact with Miss Walker, which whatever that means, right? That's like a trap door, right, guys? That's like a punji stick trap for a Vietnam soldier or Marine or Navy SEAL, right? Or a pararescueman or whatever. So, and in other words, no social media. The court found that he had engaged in these acts. And I think that the court abused its discretion. This is where I part ways. I do believe that if this was in California or Texas, I believe that the court abused its discretion in finding that Lane did not have a legitimate purpose, and that the acts that Lane engaged in, that other people carried out, other things, constituted harassment. I think now that the judge has been faced with the actual law and what happened here with the legislature, and just a good solid argument that probably couldn't have been made at the actual hearing because it requires research, that the court should have reversed itself sua sponte on the spot. And I think that this judge still has the power to go home tonight and tomorrow issue an order reversing this. I think that the findings that the judge made were issued in error, and I believe that it was wrongly decided. I don't think that the judge is a bad person. I know a lot of you guys hate judges and hate lawyers, but I think that a lot of people get into trying to be judges because they want to do the right thing. And he may be one of those judges. But he works inside of a system that most of you don't work inside of. And so I'm praying to God that the judge will see the error, because I think it's clear error. There should have never been a finding that anything Lane did here constituted harassment. And certainly there should have never been a finding that Lane had no legitimate purpose to contact her. Now, the injunction was served on him outside the courtroom. And then I believe she's saying it was served on him in court. I thought it was served on him outside the courtroom, if I'm not mistaken. Correct me if I'm wrong. Following that date, Mr. Myers kept on his YouTube page the videos with Miss Walker's contact information. By the way, that same contact information is on the university's website. So I think it's a legal impossibility for this type of an order to have been passed down onto Lane. I think it's absurd. Give me a bunch of ones if you agree. How absurd is that? That he's got to take his video down, but she doesn't have to take her official university website contact information down, because wouldn't she be harassing herself for having it available on a public website? Anyways, in January 2025, Mr. Myers posted a phone call with Officer Valenzuela, during which he references that if there had been no case with Matthew Walker, no calls would have been made to Shannon Walker. And that, in other words, if this victim's husband had been prosecuting Lane, he would not have contacted her. That's the argument. And of course, this is her framing it, by the way. She's just, making an argument. She's not providing evidence. She hasn't provided a copy of the transcript. And it's basically an opinion. It assumes facts, not an evidence. And so when I get things like this, I immediately I file what's called written objections. And I would object to every single one of these statements that were made by her, because they're not true. They lack foundation. They're argumentative. They assume facts, not an evidence. They call for legal opinions. They're conclusory. I mean, there's so many objections that could be made. These are not factual statements. These are her opinions, and she's framing them as fact. Very amateurish. And if I was a judge, I would call her out on this. I would call her out on this. Absolutely. In that discussion, he states that Miss Walker should be fired for the actions of her husband, like his wife was fired because of him. Well, again, remember the argument is that Mrs. Walker got, or Mr. Walker, I think it was Mrs. Walker though, got Lane's wife fired, who had worked for a federal judge as a clerk. And so he was pissed. So he's trying to find out what the hell is going on. So he's trying to find out, who are these people? Why did you get my wife fired? I want to interview you. I want to know what makes you think, just because you're a public official, that you have the right to basically force my wife out or threaten her with her bar card if she doesn't voluntarily resign. And that's what I would argue if I was the defense attorney. So anyways, he continued posting videos, and then he received a summons, blah, blah, blah. He was arraigned. Release conditions were imposed. He posted 2 more videos. Oh my God, he posted YouTube videos. It's the horror. She's arguing now in her law and argument that the harassment statute does not regulate constitutionally protected speech nor expressive conduct. Well, I think that's just a complete joke of an argument. Of course it does. It prevents it. So her argument that it doesn't regulate it is irrelevant. It prevents it. So in a way, it does regulate it. It prevents speech in connection with this statute. It prevents you from petitioning your government for redress of grievances or facing prison. I mean, this is something that a prosecutor in communist China would love, but I'm just shocked that a prosecutor in Arizona would even try to use this statute, knowing how it deprives someone of the right to defend. I mean, to me, like, this is when you start talking recall elections and stuff like that. Anyways, the statute has been amended to not include the intent language, which she admits. I read through this. I don't find it persuasive. I think that she makes a lot of self-serving and specious arguments in this brief. They don't hold they do not pass judicial merit, in my opinion. She's saying that he doesn't have standing to challenge on the grounds of vagueness or overbreadth. Well, of course he does. Of course he does. In California, he sure would. In Texas, he sure would. She's saying that the challenging party has to establish beyond a reasonable doubt that the statute violations some provision. I think that's a typo, that the statute violates some provision of the Constitution. I think guys, go take a look at Byrd versus State. If a court found that at the appellate stage or at the writ stage, that a party is required to establish beyond a reasonable doubt that a statute violates some provision of the Constitution, I think that needs to be further looked at, because I think that the way it's being cited here is improper, just based on my opinion. Now, generally, a defendant may raise a vagueness or overbreadth challenge to a criminal statute only if he or she actually was injured by the allegedly unconstitutional statute. The guy's been in prison. He's been in prison. You're telling me he hasn't been injured? The guy's in jail. So this is a specious bullshit argument. I don't think that this has any merit whatsoever. And then she talks about this narrow exception for First Amendment cases. You know, when I read this thing, it's so short. It's like 7 pages. I think she knows it's bullshit too, because she's not even really making. I mean, this looks like a paralegal, maybe first year out of paralegal school wrote this. There is just nothing here that holds this. This does not pass judicial muster. This does not impress me at all. All right, so let's take a look here, guys. So what do you guys think so far? What do you guys think? I think that I think his name's Parvin. I think he did a pretty decent job. I'm one of these guys that'll make like 50 arguments and do written objections. I'm over the top. So, but there's something to be said about brevity. And I think Justice Scalia, one of the books that I read that he wrote, talks about brevity. And I think Parvin did a great job. I think the prosecutor's opposition, I give it about a 0 on a 1 to 10. The arguments that she made, the specious, self-serving comments, the assumptions of facts not in evidence or yet proven at trial, should be disregarded by the court. And I think that Parvin's motion should have been granted today. And I do believe that the court was going to grant that motion. And as I also told you, when I felt that the judge start hedging towards the end, that he was going to take it under submission, or he calls it under review, I guess. And so that's what ended up happening. And now we got to wait another, couple of weeks to hear what's going on. But hopefully you guys learned something today. Looks like I got, oh my gosh, Robert, thank you. Robert Stubblefield just gifted a membership. Thank you guys. Give me a bunch of ones for Robert. Thank you for supporting Team MPE. You guys hopefully got a chance to hear the last part of the hearing. Now, if you go back to Reluctant Prophet's channel, you'll be able to hear the whole hearing that went down today. And so I definitely would like you guys to do that. He did a live show today. Reluctant Prophet's a legit dude. He's been a good friend to Lane. A lot of respect for him. Oh my gosh, check it out. Niren Nalm, Alonis versus United States 2015 is a newer case on this. I'll take a look at it, bro. I will take a look at it. By the way, another reason I'm hurrying up so fast is because I got to make a head call, guys. So I'm going to call it a, hey, Reluctant Prophet. Yeah, man. So everybody, give me a bunch of ones for Reluctant Prophet. Great show today, brother. I have a lot of respect for you for standing tall for your friend, especially knowing, you're working against a lot of evil and a lot of demonic activity, brother. And I really, really respect you for what you're doing. And so, guys, make sure to like and subscribe to Reluctant Prophet. Support him in any way you can, him as well as this is a public service. Two really good guys, non-attorneys that have hearts of gold, and I believe are spiritually gifted individuals with just really good hearts. And those are the kind of people that we really should have in government. Give me a bunch of ones if you agree. So if anybody has a heating or air conditioning issue in Arizona, reach out to Reluctant Prophet. He's your man. If anybody gets in a car or a truck accident in California or Texas, I'm your man. If you have other issues, a criminal defense or an appellate problem, I'll still try and help you find a lawyer. But right now, my expertise and what I want to stay in is what I'm really, really good at, and that's doing catastrophic injury claims. Unless it's a constitutional issue involving a police shooting or a tight handcuff case, I really try to stay narrowly focused on what I'm really good at. And so you can be a master of none, right? Or a master of one in law. And so you really have to focus. So I just want you to think about this. Imagine that the law is like a big like Empire State Building. All right. And that all the different practices in law, from mergers and acquisitions to civil rights to contract law to family law, just millions of different potential practice areas. Now, I want you to imagine a tiny little file in the basement at the very bottom of the Empire State Building. And that's personal injury law, right? Just imagine that. Just personal injury plaintiff's law. And then imagine another file, personal injury defense law, personal injury appeals, personal injury writs. And so I'm good at personal injury plaintiff's law. And I'm also good at this other stuff, but I've mastered the personal injury aspect. And I've gotten some of the largest verdicts and settlements in the state of California for motorcycle accident victims. Most of my clients are military veterans, primarily U.S. Marines. I hang out with bikers. Those are the kind of people that I like. And so I hang out with the Leathernecks Motorcycle Club. I like fully patched biker guys, and those are the kind of people that I can relate to, because I am a hard man, and I want to hang out with hard people where their yes is their yes and their no is their no, and they have a strong sense of honor. And I do find that the biker community and military veterans, primarily Marines, offer that to me. And so those are the types of people that I try to help. But it doesn't mean that after 20 years in law and having extern for the California Court of Appeal, that I haven't learned a thing or two. And so I'm sharing with you my general knowledge of general legal principles. It by no means that I'm a master at any of this stuff, and I'm not professing to be. I don't want you to treat me like I'm special. I want you to teach me things too. And so when I see somebody pop up with a cool case, like I just had, hold on, like, gosh, Niren Nalm, you make it hard, bro. You make it hard, but with your name. But when you guys come up, that's what I want, because being a good lawyer, just like being a good human being, is about iron sharpening iron. We become stronger when we unite and we help one another. These people who are braggarts and want to act like they know everything, those guys are idiots, and you should disregard everything they say, because if you're not capable of correction, you're not capable of anything. And so to me, you're just full of it. You're a narcissist. And so we need to make sure that that's what's going on. And yeah, honing your skills, says Lenny Melly. That's right. Oh, Brandy Swaney. Yes. Oh, by the way, so one of the other ways you can help support my channel is pick up a copy of my ebook, the digital version of this book, My Journey to Becoming a Practicing Lawyer with No Law Degree or Undergrad. I'm one of about, at the time, 80 people in the state of California, which still is the single most difficult bar exam in the nation, to have become a lawyer with no law degree or undergrad. And I think I'm the only graduate of the law study program to have been selected to extern for the California Court of Appeal. And so I've got a pretty cool background, and I was accepted into a law school. Check this out. They waived my first year law school courses, and I'm the only student in the history of any law school that I know of in California to have graduated from law school already a sworn practicing member of the California State Bar. That is cool. And I'm not bragging about it, but I got to tell you something. Being able to tell your kids stuff like that is an amazing thing. And I am proud of myself, and I'm proud that my kids know that about their father, because that is the example that parents want to be for their kids, to achieve the unachievable, to go where no man has gone before, to do great things and inspire others. And that's what I try to do. I want to inspire all of you people who are down on their luck. I slept on park benches. I used to be Rodney Dangerfield's limousine driver. Before that, I had a construction business. I sold my interest in the limousine company and lived off that money and slept on used credit cards and slept on park benches in Venice, California, and studied under several different lawyers, begged them to let me work for them for free, and ultimately became a lawyer with no law degree or undergrad on the California State Bar Law Office study program. And I find that I'm also an honorably discharged, disabled United States Marine. And so getting injured in the Marine Corps is what led me on this journey to becoming a lawyer with no law degree or undergrad. And just that fighting spirit, right? That Marine Corps combative spirit made me want to be a lawyer. And you guys, most of the other people know about, how I had an altercation with a cop in West Covina because I demanded his photo ID, ended up getting falsely charged with resisting case, got that thrown out and sued him and under civil rights. And that's what really locked it in. That's what locked it in for me. So that's my story for all you guys who don't really know much about me, who are just joining me today. And so I sort of gravitate towards the outlaws, because when laws are so voluminous that everyone is going to break something, we're now all outlaws. Give me a bunch of ones if you agree. In this country, in this administrative state, where we have so many stupid laws and stupid regulations, all this Marxist nonsense that from both political parties, we're all guilty of violating something. So everyone is an outlaw now. So why not hang out with outlaw bikers? Right, guys? Give me a bunch of ones. So those are the kind of people that I relate to. People who don't rat their friends out, people who don't share contents of private conversations. My oath as a lawyer is no different than my oath as a man. You don't share private conversations. When someone tells you something in private, you keep it to yourself. That's what it's all about. And thank you, Robert, for supporting my channel. Gloria, Copser 5150, Reverend Doctor, Lenny Malley, all my homeboys, Life Under the Microscope. Oy vey, good seeing you, my brother. Thanks for supporting my channel. Everybody pick up a copy of my ebook. It's only $19.99. Even if you don't want it for yourself, you go to my profile page on my YouTube channel, and all you got to do, there's a link. You click the description, you click on PayPal. It probably take me a couple days to get it out to you, but I'll send you the digital version of my ebook. And as I make changes to it, you'll get those changes because it's digital and it's locked in through Google Docs. And thank you, Brian Blowers. Cool name, by the way, Brian Blowers. Love it, man. And then I like the name Reverend Doctor. That's pretty cool. And Reverend Doctor says he served in Somalia with the Marine Company. No doubt they were tough. Well, not only are Marines tough, Reverend Doctor, what I love about the Marine Corps is the do or die mentality, the discipline and spirit. When I'm out on the street, I can tell a Marine veteran over any other branch. Well, except for like SEALs, they kind of have a similar sort of swag to them. But Marines are just highly disciplined. And when we get out, so let me just share something with you guys, and then I'll head out. You join the Army, you join the Air Force, you join the Coast Guard, you join the Navy, but you become a United States Marine. It stays with you forever. It is a It is a religious experience. There's no other way I can explain it. But for those of you who served or who know Marines, I think you know what I'm talking about. And that is what stayed with me forever. And that's why I get so many cases as a personal injury lawyer from Marines and veterans in general. Like my best client, I got him $10 million in a motorcycle accident case. He was Army Airborne. And he was like, oh, I'm hiring you. I know you guys are badasses. You're not going to let me down. See, so once something else just really quickly. In the Marine Corps, being on time is late. Remember that. Being on time is late. So you'll always notice that your Marine buddies, even if they've been out 20 years, when you tell them to be somewhere at 5, they're going to be there at like 4:20, 4:15, because that's how we are. Because we can never be late for formation, because if we do, we're going to let our buddies down. And it's a really big deal. So that is what I've integrated into my practice. That's what I try to integrate into YouTube videos. And I try to integrate into my life and sharing these stories with you to hopefully motivate you and let you see that there's light at the end of the tunnel, especially for people who have just lost a loved one, someone who's been doing time in jail. Always remember, that our law and our customs and traditions in America comes from our Creator. That's in the Declaration of Independence. I believe in natural law. I believe in homesteading, homeschooling, collecting your own rainwater, growing your own food, and getting off of this government-run system. Get your kids out of these crazy public schools. If you saw my video, if you didn't see it, watch the video I posted the other day. You've got these left-wing commie public school teachers trying to teach kids how to use butt plugs, the rainbow flag mafia. I mean, that's ridiculous, guys. If you want to learn about homeschooling, I'm very good friends with Brett Pike. He's a good friend of mine. I'll help you start your journey to homeschooling your kids. It's not like what you think. A lot of it can be done online, and you can keep an eye on your kids and bond with them and build a relationship with them at home. There's specialists and other teachers who are part of these programs now, typically pretty spiritual people, by the way, who are retired from the public school system because they know that the demons took over our school system, like far left commie pieces of garbage took over our schools. And they have gravitated towards homeschooling because they want to help people like you and me. So any of you guys have questions about that, that's what I'm hoping that I can effectuate here. I'm not here to try to make a bunch of money. I don't make money off YouTube videos, guys. And you don't see me doing personal injury law videos, which is what I do to make money. I do stuff where I've got to field calls and emails and stuff from people who keep asking me to help them with stuff that I don't do. But nobody else has given you any information about this constitutional stuff. So I'll share it with you, and I'll try to help you find someone, even if I can't do it. Okay, fair enough. Just, please at least understand, I'm trying to share things with you, but my goal here isn't to be your boss or run anything. My job as an American is to teach you how to be self-sufficient and self-reliant. I want you to know the law and mean to keep it well. You have to have somebody at least give you the basic understanding and education. And again, Lenny Malley, Kurt Bronson, all my homies, Jody Shiloh, you guys are so awesome. Super, super grateful. And Gloria says, my son is homeschooling. It's easy. Not only is it easy, but it shows your children that you really love them. When your children know that you care enough about them to sacrifice your time to let them stay home instead of having some commie, freaking blue-haired mafiosa who just escaped a safe space at UCLA and wants to teach your kid how to use butt plugs. I think it's time for you guys to understand that you need to abolish the Department of Education and pull your kids out of the public school system now. Do not pass go. Get your kids out of that system. They're just going to be professional, unemployed baristas at Starbucks with a degree in underwater basket weaving and how to vote Democrat. That's all those far left school systems are doing to these kids nowadays. They don't teach critical thinking. So anyways, guys, it was super, super awesome to be able to see you guys today. I do have to make a head call. I'm going to go ahead and get out of here. Reverend Doctor, man, it was super awesome seeing you. So make sure to like and subscribe. Make sure to save. So when I say save, I mean like save for later. Click on my videos and save to your favorites, like save for later. There's like a little button on there or something that you can press on YouTube to save it to your favorites or to save for later viewing. that is a major signal with YouTube that you like my stuff. And since I do pretty lengthy videos, if you're a long haul trucker or you do a lot of long trips, my videos are really great to listen to, and you get a lot out of them because I do share a lot of really valuable information. So do that. Make sure to like and subscribe. Make sure to save. Get your kids away from the blue-haired mafia and out of the left-wing commie public school system as soon as you possibly can. Make sure to like and subscribe. Make sure to save, because we never know when the thought police, like the people prosecuting Lane Myers right now, are going to take down this channel. Semper Fi, do or die. Hoorah!